everyone. I thought we would get started, and maybe some other folks will trickle in. My name is Emily Chang. I am the legal director at the ACLU in Washington, and it is busy days. So I, unfortunately, am not going to be able to stay for the presentation, but I wanted to introduce these two wonderful advocates and community members and leave you in their very capable hands. So with us today, and I believe speaking first, is Leah Rutman. She is policy counsel in our office at the ACLU. Leah focuses her work on healthcare, the intersection of religion and healthcare, all of our hospital stuff, and she was one of our fabulous attorneys on our coffee case involving the Reproductive Privacy Act, which I believe she will talk to you about. We also are very lucky to have with us Sara Ainsworth. Sara is the advocacy director at Legal Voice, which is a great Washington state-based organization that addresses and focuses on the rights of women. Sara, she is a longtime Washington State resident. She teaches at multiple local law schools, and she was most recently with the National Association of Pregnant Women, but we're very glad to have her back fighting for our community. So without further ado, I'm going to leave it to these two. They will each talk, and there will also be time for questions at the end. And thank you so much for coming.
Hi, welcome. We're so excited to speak with all of you today. So today we're going to be talking about abortion rights under a Trump administration. So on November 8th, 2016, some of you, if not most of you, may have felt like this. I know Sara and I did. And some of those fears are probably pretty well founded. But others of those fears may be the result of confusion. I mean, this is one quote that our now president made regarding abortion. If you put another two or perhaps three justices on what's really what's going to be that will happen, it'll happen automatically in my opinion, because justices on the court. So it is understandable, therefore, that you would be confused. We spend our days doing reproductive health work, and I don't know what that means. With that said, we wanted to have the CLE to talk to everyone, to essentially say, these are the things you should be worried about right now, and these are the things you shouldn't worry about. There are some things that are going to be okay, and other things you should really be focusing on and using all your efforts to sort of counter. One thing that I hope you're all able to leave with is we are really lucky to live in Washington State, because while things might not be great on the federal level right now, we have some amazing protections here at the state that should continue. And actually we'll learn how to work with. Not that it's okay.
Okay, hi everybody. Thanks for coming out today. So here's the part where we're telling you to kind of take a deep breath and not panic. The abortion right. At this moment, it's secure. So I think what everybody wants to know is what will happen when a new Supreme Court justice gets appointed. Well, if we look at the most recent abortion decisions, we can see that Justice Kennedy is still the swing justice, Justice Kennedy is still on the court, and there will still be a majority in favor of protecting the abortion right. Even in, and we'll talk a little bit more about the most recent decision. With that said, we don't know and cannot predict whether there will be retirements or other losses from the current makeup of the court during the time of this administration. So yes, there are things to worry about, but the time to panic about the actual right itself is not right now. Access to abortion has been at risk ever since Roe versus Wade was decided in 1973, and that remains true and is likely to continue to be true. So there's sort of good and bad news on that front. So really quickly, Planned Parenthood versus Casey is really the decision. People talk about Roe versus Wade, but it's Casey that really sets out the parameters of the abortion right under current law. And what Casey created was a standard for reviewing abortion regulations that basically says the state is going to regulate abortion. They cannot do it in such a way that would place a substantial obstacle in the path of a woman seeking an abortion. And the question of what a substantial obstacle looks like has been litigated significantly since 1992. And unfortunately, has resulted in a huge number of restrictions being upheld in the states throughout the United States. So this chart just shows you how many restrictions were enacted. So you can see abortion was illegal prior to 1973 in most states, not all. And one of the states that had repealed its abortion criminal codes was Washington State. So we were already a forerunner on the abortion right way back then. And then you can see over time that abortion was pretty free of regulation, and then just an enormous spike in 2011 in the numbers of restrictions that were put in place, in my view, while constitutional, not at all necessary to protect women's health, which is one of the interests that has to animate these kinds of restrictions. And there are over 90 current different types of restrictions throughout the United States. Now, I don't have this slide to show you, but there's an organization called Americans United for Life, and every year they rank the states according to how protective they are of fetal life. And we are 50th almost every year. So that's a proud, proud thing. We have almost none of the restrictions here. We have extremely strong laws, and Leah is going to tell you more about what Washington state law says about abortion rights. And then even at the federal level, and even in those states with those 90 restrictions plus, we have some more hope. Star Wars reference, intentional. Whole Women's Health versus Hellerstedt was just decided last year. It was such a fabulous decision. There was so much fear about what was going to happen, and that was the case involving Texas's rules that essentially put almost every abortion clinic in the state out of business. So essentially required them to have so many different types of medical equipment, physical plant standards that are required for ambulatory surgical centers, which we also have in Washington State. We have some rules around what an ambulatory surgical center has to have, but abortion clinics are not ambulatory surgical centers. The services that they provide do not, none of that is needed on a medical basis to protect the health of the people that use the clinics. So that was one of the restrictions, and then the state came and said, well, we needed to protect women's health because abortion clinics aren't safe, because they have no evidence that that was so. And then they also said, and it's not really a burden for women, it's not a substantial obstacle because all of the women in the Rio Grande Valley can drive to New Mexico to get abortions. It's only 100 miles or so, or more. Or they can all go to the clinics in San Antonio and Houston and Boston. And the Supreme Court faithfully said, no, if this standard actually has some teeth. We're not just going to say to the state, you can enact any regulation you want if you just say that it protects women's health. You actually have to have some evidence that that's so. And then the court went on to talk about the ways that this actually undermines women's health. And there's a really lovely moment where Justice Ginsburg said, if you're saying that these rules are necessary to protect women's health in your state, they don't have those rules in New Mexico, then you don't get to tell me that it's fine for people to go to New Mexico, and that I should just agree with you on that. So that was a beautiful moment for me listening in. And it was a beautiful moment for many people. We were celebrating and extremely happy after this victory came down. So I think the upshot of all this is, right now, we have pretty strong federal jurisprudence that protects the abortion right and will increasingly protect access to the abortion right. We have even stronger state jurisprudence and state laws that protect it, but there are so many other ways that reproductive rights and health are at risk right now. So I'm going to talk through a couple of those at the federal level, and then we'll pass it back to Leah. So the Affordable Care Act, unlike the federal abortion right, is not at all secure. And I think we all know that the repeal is imminent, and there are many, many things that people stand to lose. Now, abortion coverage is not one of them. Abortion coverage has always been excluded from the Affordable Care Act. The exchanges are not allowed to include abortion coverage. So what Washington State did right away, and this was advocacy from the ACLU, Legal Voice, and Planned Parenthood, and other colleagues together, right away went to the state and created a workaround. So if anybody gets insurance through the exchange, you may have seen this already, or you may know someone who has, you just pay $1 fee to add abortion coverage to your insurance if you need it. We tried to do it without a fee, but that covers the administrative costs of managing the extra coverage rider. And our state picks up the tab for the rest of the coverage. So that's super important. Our state always tries to kick in and provide the services that the federal government doesn't want to provide. So abortion coverage is not going to change if the Affordable Care Act is repealed, but other really, really important things are going to go away. How many people are familiar with the contraceptive mandate? A few people? Okay. So what the ACA did was essentially allow the government agencies to create regulations to decide what kind of preventive care services are covered. Birth control is one of them, so birth control without co-pays, without cost and out-of-pocket costs to the recipient. That's supposed to be covered by all insurance programs under the ACA. You are probably familiar with the legal challenge that some religious employers brought and unfortunately succeeded in having themselves not only get exempt from this coverage requirement, but also unfortunately expanded the law of corporate personhood to say that a corporation can have a religious conscience. So very unfortunate decisions there. Nonetheless, there are still thousands and thousands of employers around the country that are subject to the rule, that do have to make sure that their employees have access to contraceptive coverage, and of course the healthcare exchange is included as well. That mandate will go away, and so we will be subject to whatever the states allow. In Washington State, we have a contraceptive equity rule that requires all plans to cover contraception. However, they don't have to cover it with no out-of-pocket costs to the covered person. And what we know that's problematic about that is because so many women are on some form of contraception for a very significant time in their lives, women's out-of-pocket costs for health insurance end up being much greater than men's. Keep advocating around. We also know that there's all kinds of other preventative care that's covered by HHS and requires breast cancer screening, other kinds of screening that will no longer be covered and required under federal law and will be subject to state rules again. Medicaid expansion, 12.3 million people around the country gained health coverage and they stand to lose it upon repeal. And then super briefly mentioning Section 1557 of the ACA, is a super lawyerly thing to say. That's a rule under the ACA that basically says you can't discriminate in the provision of health care, and it includes gender identity. So for the first time, we had a legal protection for people who are transgender for gender-affirming health care that was national in scope, not just here based on, say, our anti-discrimination laws. That is expected to be repealed. Probably already will be not enforced at the federal level, given what we know about the current administration. But that's been very important, and it's also protected reproductive health care access as well. And then the other big awful thing that we're looking at is the defunding of Planned Parenthood. We know that that's high on the agenda and that the votes are increasingly there to make that happen. What that actually means, Planned Parenthood receives about $500 million annually. They operate 650 health centers around the country. They serve millions of people, primarily low-income women, adolescents, and immigrants. They do not provide abortions with any of those federal dollars, and they never have. And so, because what they're doing is providing preventative services, they're actually saving money. So even if you step aside from the human rights angle and look at just the economics of doing this, this will actually end up costing the country significantly more money over 10 years, $130 billion if we decrease this. So I'm going to pass on to Leah to mention another bad federal thing, and then she'll move on to the state.
So Planned Parenthood and the Affordable Care Act are probably the things you've heard the most about in the media and from the administration in Congress right now when we're talking about what might happen with reproductive health. But it's important to also know that there are other abortion restrictions that we should be keeping an eye on. The Hyde Amendment is probably the most famous of these restrictions. It was enacted by Henry Hyde, who, as you can see, was hoping to deny all women access to abortion, but he felt it was unfortunate. The only vehicle to do so was the Medicaid bill, so he ended up denying abortion access to poor women. So the Hyde Amendment essentially denies federal funding for Medicaid for the purpose of abortion. So women who are on Medicaid, the federal funding component cannot cover abortion. Many, many states have also fallen into line with the federal government and refused to provide coverage for abortion. Washington State is not one of them. We're one of the few states that do provide coverage for abortion, which is great. One reason to keep an eye on the Hyde Amendment is over the years, similar restrictions to the Hyde Amendment have been enacted. So initially this was, federal funding for Medicaid, and then similar restrictions related to Native Americans, relating to military personnel, related to federal employees have also been included under the types of restrictions of federal funds not being provided. So it's just good to keep an eye on that. Beyond Hyde, how many of you have heard about the Weldon Amendment? I think Sara has, that's one.
Not surprising.
So most people have not heard about the Weldon Amendment, but the Weldon Amendment is really something we should keep an eye on with this administration. So the Weldon Amendment, I believe, was enacted in 2005, and what it essentially says is none of the funds made available in this act being available to a federal agency or program or to a state or local government if they discriminate against a healthcare entity on the basis that the healthcare entity does not provide, pay for, provide coverage for, or refer for abortions. So what does that mean? So first of all, the funding, I mean, that's a great question, right? The funding we're talking about here, we're talking about a lot of money. We're talking about the money, federal labor, education, and health and human services money. When the Weldon Amendment was challenged in California, they were saying they were talking about California potentially losing billions of dollars. So we're talking about a large amount of money that can be lost if you're found in violation of Weldon. But what does Weldon mean? They're saying you can't discriminate. What does that mean? Actually, Weldon doesn't define discrimination. So there's been a lot of confusion over what Weldon does mean. States don't really know what can put them in violation of Weldon. And the recourse is kind of interesting because to gain recourse under Weldon, you have to go through the Health and Human Services. So obviously, Health and Human Services was previously under the Obama administration. So if you had a complaint under Weldon, you would have to go through essentially the Obama administration. Now you would have to go through the Trump administration, and we don't have a clear understanding of what Weldon means. So how could that play out? I'm going to use California as our case study because this recently came up. Basically, back in 2014, California decided that abortions were basic health care and health plans had to cover. They sent letters to, I think it was 7 insurers who actually already provided abortions in some of their plans, but not in certain specific plans, and said, hey, you need to be providing coverage for abortions. All the insurers did not complain about it, they had no religious objections, they were happy to provide this. However, HHS, the Office of Civil Rights for Health and Human Services, received, I think, at least 3 different complaints from outside entities, such as, churches, a church-run school, basically saying that this was a violation of Weldon, and therefore California should lose its funding if it kept on with this. So HHS thought about this, and they analyzed the situation, and HHS under Obama came up with 3 central findings. First, they said, Weldon protects only healthcare entities, so we'll protect the insurers, but it's not going to protect these essentially random entities that are complaining about this because they're not impacted. It's only the healthcare entities that are identified under the Weldon Amendment. Number 2, Weldon protects only those covered entities that object to abortions. Remember, none of the insurers objected. And the purpose is to protect entities whose objections are made on religious or moral grounds. So that's sort of getting to the heart of what constitutes discrimination under Weldon. Is it really, really broad? Or is it supposed to ensure that people who have religious or moral objections aren't discriminated against? HHS under Obama said, let's look at this in a more narrow way, right? They also said, which was really interesting, enforcing Weldon may be constitutional. So why is this? We essentially have the 10th Amendment that says if certain powers are not given to the United States, the feds, and they're not prohibited by the states, then the states get to have those powers. The states get them. And so what you can't do is you can't have financial inducements that are so coercive that essentially leaves the state no choice. So if you're saying you're going to lose billions of dollars if you don't do this, you can't do that, right? Because the state has absolutely no choice. So HHS sort of was like, we think, they didn't come out and say this absolutely is a constitutional violation, because they didn't even have to go there because they had the first 2 findings. But they said, hey, we think this may be unconstitutional. This is so interesting because now we're going to have an HHS and an OCR under Trump. Would a Trump administration find something similar? Unlikely. A lot of people were upset with HHS's decision. So So I think we're likely to see a lot more Weldon challenges, and we might see HHS coming up with something different, and we might also see Congress trying to create a private right of action so that you don't have to go through HHS, so that individual entities can come forward and make claims without having to go through sort of this administrative process. That's something to keep an eye on. The one thing I'd say though, the one like silver lining there, is we have the Constitution. And I think we would agree that there is probably a constitutional violation here. So if it ever gets to the point where the Trump administration is trying to enforce Weldon, I think there will probably be constitutional claims that they can't do that. So all that is sort of what's going on federally, the good, the bad, the ugly. And now we're going to talk a little about Washington State, which is primarily good. So first, let's talk about the Reproductive Privacy Act. The Reproductive Privacy Act is fantastic. It was passed by voter initiative in 1991. All of you, the people of Washington State, are like, we want this, which is wonderful. And basically, it says every individual possesses a fundamental right to privacy. Every individual has a fundamental right to choose or refuse birth control, to choose or refuse to have an abortion. And the state can't discriminate, essentially. The state can't interfere or discriminate when it comes to these rights, which is really amazing. What makes it really interesting to me is 9.02.160 case. So basically, what that says is if the state provides maternity care, information, benefits, services, it has to provide the substantially equivalent benefits, information, services to allow a woman to obtain a voluntary termination, is the terminology used there. So basically, if you're providing maternity care, you have to provide the substantially equivalent termination services. That's how you can do that. You also, at the same time, have protections for individuals in private medical facilities, which essentially says no person may be discriminated against in employment of professional privileges because of their participation or refusal to participate in a termination. And this is a really common type of provision that you'll see across states and the country. So essentially saying you as an individual have the right to refuse to provide this service. But you state if you're providing maternity care, you have to provide this. So this passed in 1991. It's a fantastic law. Washington's great, but it was never enforced, which is really interesting. Really like a lesson there. That's Sarah's great slide. It's pretty interesting. So around 2013, the ACLU started being really interested in religious secular health system affiliations and the corresponding denial of services when this would occur, especially in relation to reproductive health. And what we started to see is we have public hospital districts across our state, public hospital districts, like state entities, and they would say, yes, we are going to affiliate with the religious health system, but that's okay because we didn't provide abortions before, so we don't have to provide them, so nothing's going to change, we're still not going to provide them. And we were essentially like, well, just because you were breaking the law before doesn't mean you can continue doing that. No. So with Skagit Regional Health, basically there's a public hospital district. Public hospital district number 1, Skagit County, and they do business at Skagit Regional Health. We essentially sent demand letters and eventually followed a lawsuit, which essentially said, we believe you're violating the Reproductive Privacy Act. You are providing the full range of maternity care. You have beautiful birthing suites, you have this, you have that, and you are not providing the equivalent, substantially equivalent termination services as required under the Reproductive Privacy Act. Because Skagit was claiming it would provide medically indicated terminations, as it called them, but not what it would call elective terminations. We are saying that's not equivalent. So we made various arguments, basically saying they were violating the RPA, and they made other arguments back. They essentially claimed, they didn't run a program under the Act, that they don't provide what they deemed elective C-sections, so they weren't required to provide elective terminations, and various other arguments, including that they weren't allowed to contract or hire anyone because of that provision protecting the rights of individuals. So they couldn't contract or hire anyone to provide terminations or ask about it in an interview. So on summary judgment, which means this never even went to trial, basically the court read our briefs and was like, we win. Great. Basically the court said, and I love this line, compliance with the RPA is not aspirational, it's mandatory. Section 160 does not allow the hospital district to provide information about where a patient can obtain a voluntary termination. Rather, it requires the state to provide comprehensive care to patients seeking voluntary termination services. Failure to do so violates the RPA, essentially. And there were other, I mean, I had a really hard time choosing the best quote because I really loved this decision. But this really says it. Basically, she's saying you're in violation of the RPA and you need to get into compliance because you can't try to comply, you actually have to. This was appealed, so we're now in the Court of Appeals, Division 1, and we'll see where it goes. I think we're fairly confident that we will have a good decision again because we think we have the law on our side. And I think one other thing I just want to mention about that is this is just one part of a statewide effort on our part to get every public hospital district in compliance with RPA. It's not just Skagit. We've identified quite a few public hospital districts around the state that don't seem to be complying to provide a lot of maternity care but not substantially equivalent termination services. Jefferson County, I just want to highlight, when we sent them a letter, they were the only one before we won the lawsuit. Now others are coming forward, but before we won the lawsuit, they immediately set up a task force. They figured out what could be done, and they implemented. They started providing termination services on site at their public hospital district. I just want to give them a little kudos that there are public hospital districts that do want to raise this to their attention, comply, and we're hoping they can sort of serve as an example for some of the other rural public hospital districts. But all that to say is we have some really great laws and we can use the court systems to enforce them here, which is great. And I think I am now going to turn it over to Sara again to talk about another case.
So we thought we'd talk about a little bit about another victory that is not related to abortion precisely, but is related to reproductive health rights. So how many people have heard of the morning after pill or Plan B? And how many folks have heard about pharmacists not wanting to provide it to people? Okay. So that's what this case was about. So there started to be this kind of nationwide effort on the part of a group called Pharmacists for Life in 2004 and 2005 to get their members to use their jobs as pharmacists for political purposes and to refuse to provide birth control, so all kinds of birth control, especially emergency contraception. At the time, Plan B was the only emergency contraceptive product on the market. So they also started refusing other kind of random things too at the time, all related primarily to women's health. And this was going on in various states. The most notorious one happened in Texas where a pharmacist refused to fill a rape victim's prescription for Plan B, which at the time was only available by prescription but is now over the counter. So we started to hear reports of the same thing happening in Washington. There was a pharmacy on Broadway on Capitol Hill that refused emergency contraception, one up in Bellingham, a pharmacist in Olympia that refused to stock it at all, wouldn't sell it to anybody. So we started to hear these reports, and then we heard reports of some other odd refusals. So for example, Cedar River Clinics, which is one of the private or the smaller independent abortion clinics, here had called in a prescription for antibiotics for someone who had had an abortion. And the pharmacist in Swedish here on First Hill refused to fill that prescription because of the type of procedure that this woman had, putting her health at risk, obviously. So, and then we heard of a couple of people being refused insulin needles, which are over the counter, but still the pharmacist has to hand them to you because they were pierced and tattooed, and the pharmacist decided that they were using illegal drugs instead of eating their medications. So hearing all this stuff together, we and a bunch of our colleagues went to the state board of pharmacy and said, we need a rule here that tells pharmacists that they have a professional obligation to ensure that lawful prescriptions get filled when a patient comes to the pharmacy, and they should not discriminate against patients based on their gender, based on what kind of medication they need. So rule got passed. It was immediately challenged by a group of two pharmacists who were religious pharmacists and the pharmacy owner in Olympia, Stormans, which is the case name, Stormans Incorporated. They are the owners of Ralph's Thriftway, which is a grocery store and pharmacy in Olympia. So they immediately challenged it and said that it violated their First Amendment right to religious freedom and religious exercise under the federal constitution. And that was 2007. And it wasn't until 2016 and multiple trips up to the Ninth Circuit Courts of Appeal, and we kept winning at the Ninth Circuit, and we kept losing in front of the Federal District Court here in Tacoma. And then finally, the United States Supreme Court refused to accept cert in 2016 over an extremely lengthy dissent authored by Justice Alito, who had been the author of several free exercise decisions when he was in his role as an appellate court justice before he was appointed. So it was a very narrow miss, but it did not get reviewed by the Supreme Court. So the Ninth Circuit decision stands. What it stands for is the proposition that a state can say, there's a problem. It may be true that some of the people that are part of the problem are refusing to do something and follow a law because of their religious beliefs. But that does not mean that that violates the First Amendment right to free exercise. All of us have to follow the laws. And the state can decide to exempt some people from the law. And they did, in fact, in this case. So the exemption in this case looks like this. Let's say you work at Rite Aid, and you have a religious objection to filling some kind of prescription. It's your responsibility to tell your boss that you have that problem, and it's their responsibility as their boss to accommodate you. Figure out how to make sure that the patient gets their prescription filled. The patient's not supposed to ever know that there's this behind-the-counter transaction where a pharmacist was getting accommodated, because it's not our responsibility as patients to have to go in and wait through this and be refused and delayed and not get the medication we need. And what's particularly important, the Ninth Circuit said, is that we're talking about a timely medication. So emergency contraception is only effective up to 5 days. And at the time when we passed this rule, it was only known to be effective up to 2 days after unprotected sex or a sexual assault. So extremely important that people get the medication when they need it and get it immediately. So this was a really good victory. So for the first time, the Board of Pharmacy rule has actually been in effect. It was enjoined all through this litigation. So for 9 years, the rule was not in effect. So we are, of course, at Legal Voice and other agencies very interested to hear if anybody hears of or experiences a denial at a pharmacy. We'd like to know about so we can start enforcement actions under this rule. Now, I'm going to pass this back to Leah to tell you a little bit about some of the things we have to defend against here in our legislature this session.
Yeah, so Sara and I may have made it sound like Washington's perfect. It's close. We have like really nice amendments in place. But there are problems. So reproductive health laws are great here, but there are challenges, right? And right now we have the legislative session, and every session we see various bills that are trying to attack abortion rights right here in Washington state. The one I want to talk to you about, because it relates to the Reproductive Privacy Act that I was discussing, is HB 1002. I think as long as I've been doing this, I see some version of HB 1002 basically every single session. And essentially, it would gut the Reproductive Privacy Act. As I mentioned, the Reproductive Privacy Act ensures that every woman has a fundamental right to choose or refuse an abortion. Basically, this changes that language to say only medically necessary abortions. And medically necessary abortions are defined very narrowly under this bill, you know, limited danger of the woman, all that type of language. So that's a huge restriction, right? It is no longer that a woman has the right to choose whether she wants or doesn't want to obtain an abortion. Similarly, this bill is really broad. It would essentially deny public funding for anything other than medically necessary abortions. So as I mentioned before, we're one of the few states that provide Medicaid coverage for abortion. That would no longer be the case under this. Public hospital districts would not be able to provide these services. Public universities would not be able to provide these services. More so even, this is so broad that public funding would not be able to go to entities that essentially have any interaction with abortion providers, even if their interaction has nothing to do with abortion. So essentially, you provide money or exchange services with Planned Parenthood for something that has nothing to do with abortion. Planned Parenthood provides so many services that don't have anything to do with abortion. You would therefore no longer be able to receive funds from the state. So it's this incredibly restrictive bill that would really get the Reproductive Privacy Act and deny women the right to choose, and we keep seeing it, which is obviously a concern that people keep trying to push this forward in Washington state. The good news is it has not been successful, and I don't see it being successful this session. And a couple others, I'm going to switch it back to Sara.
So, yeah, the same kind of bad things happen every year, and we expect a little more to come. The deadline for dropping bills in the legislature is February 17th, so there'll be a longer list before we're done. But currently, right now, there's a couple of companion bills, one in the Senate, one in the House, that would require parental notice before a healthcare provider can provide an abortion to a minor. We are one of the few states that do not require parental involvement in a minor's abortion decision. We also protect minors' rights to decide to be in mental health treatment, to to decide to be in chemical dependency treatment, to get STI care. Minors have a lot of confidential health care rights under Washington state law for good reason. And those rules were all passed and propounded, and those rules were brought forward by advocates for youth and youth themselves, and all kinds of terrible stories about what happens to young people who feel afraid or face danger when they talk to their parents, or who just for whatever reason are uncomfortable doing so. So Washington has held out long against these kinds of laws. Oregon also has held out. They've defeated Citizens Initiative twice to try to require parental involvement. California has an enjoined law. Alaska has an enjoined law, and Montana has an enjoined law, and that sort of swath of states other than New York and a couple of other small eastern states are pretty much the only states that don't limit minors' rights in some way. So what that means, for example, is girls in neighboring Idaho often come to Washington state. So kids end up traveling to avoid having to tell their parents, and that's what we went down to the legislature last week to tell them. Like, this isn't good for kids, it's not good for their health, and it's certainly not medically indicated. So that bill, like the one that Leah told you about, is very unlikely to go anywhere this session, given that we have pro-choice people still in control of the legislature. I think we want you to recognize how important it is to maintain that pro-choice majority in our state legislature and also in the governor's office. So that protects us against becoming like the other states with numerous restrictions. And then there's House Bill 1775. It's called Enacting the Washington Pain-Capable Unborn Child Protection Act. Does anyone know what that means? So, for some of you probably have heard about this, that what it means is there's this idea that some science says that a fetus is able to experience pain or reacts to what would be a painful stimuli at 20 weeks and beyond. Lots of science says the opposite. Anti-choice folks have used this to basically enact bans on abortion after 20 weeks, which have been held unconstitutional in the Ninth Circuit and in other jurisdictions as well. So any of these bills would be subject to an immediate legal challenge. We would not only have our state and federal constitutions to use to challenge these kinds of laws, but we would have the Reproductive Privacy Act as well. So even if they were to get through and pass, we would have a lot of legal challenges to them. But essentially, don't be fooled. That's not about protecting anyone. It's simply about banning abortion. And then I'll pass it back to you. What shall I want to say? Okay, great. So in other news, we thought we'd mention that in addition to the courts, in addition to a pro-choice legislature, we also have the people, right? The last defenders of democracy and the last defenders of our rights. So we want to point out that right now there's just been this gigantic surge of progressive people coming forward to defend all of our freedoms. Reproductive health and rights was one of the key freedoms that the folks at the women's marches in DC, here in Seattle, all around the world were defending. So you should also know that there's been a huge outpouring of support for the ACLU, for Legal Voice. We have currently more lawyer volunteers that we know what to do with, and even more non-lawyer volunteers that we know what to do with, and we're working on that. And anyone who wants to volunteer, I welcome and encourage you to do that. I know that it may take us like 2 weeks to get back to you, but we will bring you into this process. So it's a time that's, besides all of the horror and daily fresh hell that you're facing, we also have a significant outpouring of all of us to defend progressive causes and to defend our rights. So I want to thank everybody for being here today, because I imagine you're here in part because of all of this. So thank you. And now we have time for